is on the need to invite the Honorable Minister of Justice and Attorney General of the Federation and other relevant stakeholders to brief relevant committees of the Senate on the award of $9.6 billion against the federal government of Nigeria by a United Kingdom court in the matter of P&ID, again, Process and Industrial Development Limited versus Federal Republic of Nigeria. Mr. President, the Senate notes with concern that Nigerians at home and in the diaspora have become apprehensive while several committees of the Senate have, over the last few weeks, received several petitions and other direct and circumstantial information on the ongoing legal imbroglio involving the Ministry of Petroleum Resources, by extension, the federal government of Nigeria, and the United Kingdom firm known as Process and Industrial Development Limited, hereinafter referred to as P&ID. Aware that a commercial court in the United Kingdom in a suit referred to as Process and Industrial Development and Federal Republic of Nigeria has ruled that federal government must pay the British firm Process and Industrial Development Limited a sum of $9.6 billion or have its assets to the tune of that amount forfeited. The Senate is further aware that in January 2010, the Ministry of Petroleum Resources, acting on behalf of the federal government of Nigeria, executed a gas supply and processing agreement with P&ID, whereby Nigeria was to supply zero-cost natural gas to P&ID through a pipeline to be constructed by Nigerian National Petroleum Corporation to P&ID's processing facility. The Senate further notes that under the terms of the GSPA, which had a tenure of 20 years from the date of first supply of wet gas, P&ID had an obligation to process the wet gas and deliver the derivative lean to the federal government free of charge for power generation, while taking any other residual liquid for itself at no cost. The Senate further notes that based on the facts of the case, P&ID served a notice of arbitration on the federal government in 2012 on the ground that Nigeria repudiated its obligation under the terms of the GSPA by defaulting to make wet gas available to it. Alarmed that the UK court's decision converted the subsequent arbitral award into a domestic judgment against the federal government, creating a situation where Nigeria's assets around the world, particularly in the United Kingdom and the United States of America, risk being taken over by P&ID or its agents. Pained that the damages awarded to P&ID are manifestly excessive, exorbitant, punitive, and a big threat to the economic well-being and security of Nigeria. Mr. President, the Senate being deeply concerned that the issues arising from the default aforesaid, as well as the consequential arbitration, court proceedings, and the ensuing award against the federal government of Nigeria have thus far been concealed from the Senate and the entire National Assembly. The Senate reiterates that the principal role of the National Assembly is, amongst others, to undertake oversight of all government ministries, departments, and agencies, and to make or amend subsisting laws of the Federation of Nigeria for the proper functioning and good governance of the country, which power is derived from the provisions of the Constitution of the Federal Republic of Nigeria, 1999, as amended. The Senate accordingly resolves to invite the Honorable Minister of Justice and Attorney General of the Federation to, in the company of other relevant stakeholders, including officials of the Ministry of Petroleum Resources and professional arbitrators engaged on behalf of the federal government of Nigeria in this regard, comprehensively brief the Senate committees on judiciary, human rights and legal matters, petroleum resources upstream, gas resources and power on the details of the 2010 contract with P&ID as executed, the reasons for the default, as well as the handling of resultant negotiations, arbitrations, court proceedings, and steps being taken to resolve the matter in the overall best interest of the Nigerian economy and security of the nation's assets at home and abroad. I thank you, Mr. President.
Senator Abbas.
The Akwa Ibom Northeast. Mr. President, I rise to second this motion ably moved by my brother, the Chairman Judiciary, and to also state that, Mr. President, all through we're on vacation, I believe this is one matter that has dominated our public discourse. One based on the concerns of Nigerians on the need to protect and defend our collective interests. Mr. President, this agreement was consummated, I understand, sometime in 2010 in this country. I know that in the last Senate, I chaired the Senate Committee on Gas Resources. And I've read several arguments, contentment, issues for and against this process. Mr. President, as of 2008, there is a law in this land that was developed and enacted by this National Assembly to back up and protect the gas master plan, which is the basis for this project. Mr. President, Section 7 of that Act states clearly the procedure of engagement of this nature. The Ministry of Petroleum Resources had no right whatsoever because they have no gas to give to anybody. And on the basis of that law and that Act, Mr. President, it is the Gas Aggregation of Nigeria that is also act as an arbiter between the supplier of the gas and the one who needs the gas. Section 7 of that law is that. And I've also seen that no mention has been made to that law by any of these arguments. Mr. President, also the ICRC Act of 2005, let me even state clearly, sir, states clearly in section 3. It is the law of this land. It states clearly that it says, no federal government ministry, agency, corporation or body shall give any guarantee, letter of comfort or undertaking in case of any concessions agreement made pursuant to this act, except with the approval of the Federal Executive Council. This is the law of the land. So I stand here to say that on the basis of these two acts of this made by this National Assembly and assented to by the federal government, which is in operations, I don't think that there is any need for us here to overlook the contents of this motion and the issues involved, based on the fact that it is our own national reserve that is being monitored. And Mr. President, based on information also available to me, sir, the original owners of this company have been bought over by an equity company in America who specializes in this camp. So I rise here to support this motion, Mr. President, and I also want to thank you, Mr. President, because even in your opening remarks, sir, in your address, you made reference to this issue, which underscores, of course, your concerns and your passion towards the region of this in favor of Nigeria. So I rise to support and ask my colleagues to support this motion, and also the approach that the Senate has actually taken. I think is quite objective and reasonable. Mr. President, I rise to support this motion, and I urge my colleagues also to add their voices to this motion for the good and benefit of our people. Thank you, Mr. President.
Senator Solomon Diallo.
As if I may read 53.5. Reference shall not be made to any matter on which a judicial decision is pending in such a way as might, in the opinion of the President of the Senate, prejudice the interest of the parties thereto. Mr. President, all of the potential defenses just articulated by my colleague from Akwa Ibom, those are very, very powerful defenses that ought to be available to the legal team representing this country. I'm also sure, Mr. President, that it is the smartest way that on national TV, we make all of these potential defenses available to everyone, including the other parties. The cross, as I understand it, of this motion, as ably moved by Chairman Judiciary, is to have the legal team headed by the Attorney General be invited to at least in camera address us and inform us about ongoing in this litigation. I think we should limit it to that rather than have other people begin to speak to this. I so move. Thank you.
Said concerning this particular item of transaction that have generated a lot of issues across the country. Mr. President, not to overflog the issue, the prayer of the motion is clear. It's just to brief us. We are not doing any investigation or calling anybody or subjecting them into any public hearing, but at least to be brief, for us to be at least kept abreast of what is even really the issue. Because this actual amount of $9.6 billion migrated from $800 million to about $6.3 billion, an additional interest of about 3-point-something billion made it about $9.6 billion. This is a very sensitive issue. And what we're doing is, as a Senate or as a National Assembly, let us be briefed. Let us invite all interested parties just to let us at least be on the same page on this matter, so that going forward, we will know the direction the country is going on this issue. I know there are delegations that were in London for at least a defense or so, which comprised of Minister of Finance, Central Bank, oil and gas, and all of them. We are watching and we are listening, but we want to know the nitty-gritty of this matter. So I want to support the mover of the motion and those that have contributed that we are on the same page. Thank you, Mr. President.